Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. Ladies and gentlemen of the jury, I know, at least to my knowledge, all of you were called here suddenly and without participation on your part, but the reason you were called here is because there is a case ready for trial, and the jury panel that was called for the purpose of this particular jury term, which commenced this morning, has been exhausted by virtue of other trials being conducted in the district courts. The case which we are about to try is a criminal case as opposed to a civil case. It is to be tried by the people of the state of Washington against Mrs. Sorensen, who may sometimes be referred to as the defendant or the accused. The case is based on an information or charge. Now, this particular information I have just read merely is a charge, and all of you should understand that it is not in any sense evidenced against the accused. The defendant has entered a plea of not guilty to the information. The prosecution, therefore, has the burden of proving the charge against a reasonable doubt. The purpose of this trial is to determine whether or not the prosecution will meet this burden. Members of the jury in this case will make that determination. 12 members will constitute the jury in this case, and the jury will consider all of the evidence produced during the trial and reach a decision with the instructions from the court as to the law which applies to this particular case. It will be the sole responsibility of those jurors chosen to try the case to determine the facts from all the evidence produced during the trial. Now 13 of you will be called into the jury box. The 13th person will serve as an alternate juror and will take over the service of one of the original 12 in the event one of those 12 persons is unable to complete their service throughout the trial. Upon being called into the jury box, each of you will take an oath that you will truthfully answer all of the questions as to whether or not you can serve as a juror in this case. Your answers to these questions should be direct and complete. All members of the jury panel should listen with attention to the questions asked of the other persons. If your answers to any of these questions are such that we should be aware of them, be sure that they are brought to the court's attention at the first opportunity. You are to disregard any remarks of counsel which you find to be inconsistent with the evidence in the case or as charged. You are the judge of the evidence and the credibility of the witnesses. In criminal cases, the people must overcome the presumption of innocence and prove the accused guilty beyond a reasonable doubt. In a civil case, the rule is different. The burden is upon the plaintiff to prove his case and every element of it to your reasonable satisfaction by a clear preponderance of the evidence. When the attorney on both sides stipulate or agree as to the existence of a fact, or a fact has been admitted, the jury must regard that as proved. If the stipulation is that a witness would testify in a certain manner, all that the jury is required to believe is that the witness would so testify. The instructions given to the jury must be accepted by them as the law governing the case. Only one verdict on the form shall be returned signed. These instructions and the verdict form shall remain in the possession of your foreperson until such time as they are called for by the judge in open court. Upon reaching your verdict, you will inform the bailiff of this court, who will notify the court. Please stay in the jury room until called into the courtroom by the judge. Again, you will be provided with only one form of your verdict. Your verdict must be unanimous. Ladies and gentlemen of the jury, the attorneys have been instructed by the court, and they know that they are not to talk to prospective jurors in a case that they are involved in. They can, of course, greet you, but that's all they are supposed to do. If they seem sort of stuck up, they are really not. They are just doing what they are supposed to do. During this recess and all the other recesses, you are to observe this caution. You shouldn't form any opinion about this case until you have heard all of the evidence, the instructions of the court, and have retired to the jury room for the purposes of considering your verdict. All right, now let's try some literary material. And let's see. This is called A Day in the Life of a Cart Captioner. Ready? Here we go. As a very seasoned broadcast captioner who is an independent contractor venturing into more remote cart work, I have found myself overwhelmed with the amount of information I don't know. With a vast amount of work available for cart captioners, we now need to be proficient in all of the different delivery methods available, not just at the present time, but what is soon to come. In a typical month, I probably work for approximately 10 to 12 different companies. This requires some creative organization on my part. Of those 10 to 12 different companies, about half of those have their own company portals that contain all of their independent contractors' schedules and sometimes connection information. In addition, some of these portals are also used for invoicing. Keeping these portals organized with various passwords and instructions is another organizational challenge. My day usually begins the night before with one last look at my schedule and knowing exactly what the job is, how it's to be delivered, and if necessary, where I have that information. I make sure whatever resource I will need is placed on my desk the night before. Sometimes that means double checking emails or various companies' portals. First thing in the morning, I double check my schedule again, confirming my work and either requesting my prep material or doing the research myself. I'm lucky if my day consists only of broadcast captioning jobs. I'm more comfortable with the technology on those jobs. It is the various remote cart captioning jobs that can cause so much frustration because of all the various third-party platforms that are now being used. Just a few examples: Steam Text, WebEx, Skype Screen Share, Adobe Connect, Google Hangout, iCap, Blackboard Collaborate. Some of these platforms do have a cost to them, so I need to figure out ahead of time if I or the hiring company bears that cost. Many companies may have how-to instructions on these various platforms, but I certainly don't want to be learning on the job and will walk myself through the platform well ahead of time. And of course, these platforms get updated quite often and their procedures change. And then there is the issue of how am I going to be receiving the audio? Is it through the third-party platform, through Skype or Join Me? And if so, who are you calling? Once the job has been completed, each company may have different procedures for submitting the file, may want certain formats, or may ask that the file be emailed to someone or placed into their portal. There may be other forms to fill out, such as the exact length of time or to report on any trouble during the job. Again, keeping this information organized is critical not only for your daily business but the company you are working with. This type of information I keep not only in virtual folders but paper folders as well. Does the company want me to complete an invoice immediately after every 2 weeks, once a month? Do they have their own invoice form and invoice on the portal, or am I required to invoice them? If so, which accounting package should I be using? On to the next job, which actually requires 2 separate output settings, one to an encoder and one to a third-party platform. This is definitely one to test out ahead of time, as my CAT software sometimes needs very specific settings. In addition to that, each separate output can look very different, and depending on what is required may take some time to figure out. I definitely do not want to learn this on the day of the scheduled job. And now what may seem like an easy job, covering a remote Writing 101 class. Sometimes the third-party platform works beautifully, but when the audio is connected through Google Talk or AOL, the instructor is very difficult to hear. When I'm in this situation, I need to remember if the company offers inaudible audio issues or audio difficulties, or possibly something else. If I am working as an independent contractor, I hope that the company has set up the microphones and delivery method, but I need to consider if there is anything I can do to help troubleshoot the issue. Certainly, I can be in contact with the student either through instant messaging or simply writing into the cart text to have the student try to adjust the microphones, sit closer, turn up volume, etc. And when all is said and done, what are the procedures for handling the text file? Through all of this, I see the most valuable skill as an independent contractor cart Captioner is organization, and not just for your professional business, but also your home social life. With all of the above work situations and a zillion others I could have mentioned, I make sure to schedule in gym time, walks with the dog, laundry, cooking meals, grocery shopping, feeding animals, showering, banking, paying bills, and so on. I think it's a learned skill as to what works for you and what doesn't, and sometimes it's a bumpy road finding that exact fit. Through all of this, the phrase lifelong learner sure applies. Back to some jury charge practice, and the subject of this jury charge is union complaint. Ready? Here we go. This is a companion case to number 57, decided this day. International Fur and Leather Workers Union filed a charge with the National Labor Relations Board alleging that respondent, Hudson Manufacturing Company, had interfered with the guaranteed rights of its employees. This charge was filed in April 1956. A complaint was issued based on the charges in February 1957. At the hearing, Hudson sought to prove that certain affidavits filed by officers of the union were false. The trial examiner ruled in accordance with the board's practice that issue could not be litigated in the proceeding. The trial examiner recommended that an appropriate remedial order be issued to correct the unfair labor practice which he found to exist. The board in general sustained the trial examiner and issued a remedial order against Hudson. Prior to this order, the board had been enjoined from taking administrative action requiring the union's officers to reaffirm their affidavits. In August 1958, an indictment was returned against Walter Peck, an officer of the union, charging that the affidavit which he filed with the board on August 30, 1955 was false. Peck was convicted for that offense. Thereafter, the board ordered the union to show cause why its compliance status under the act should not be altered unless Peck were removed from office. The union re-elected Peck as its president. Shortly thereafter, the board declared the union out of compliance with Section 9H. The union then obtained a preliminary injunction from the district court enjoining the board from altering or restricting the union's compliance status by reason of Peck's conviction. The Court of Appeals affirmed. The board sought a stay of the preliminary injunction pending decision by the Court of Appeals in the case of Larson versus United Electrical Workers. When the stay was denied, the board petitioned the court below pursuant to Section 10E of the Act for enforcement of the unfair labor practice order. Respondent, Hudson Manufacturing Company, moved for dismissal of the enforcement petition on the grounds of Peck's conviction for false filing under Section 9H. The union intervened and opposed the motion to dismiss. The court below granted the motion to dismiss, holding that since the falsity of the affidavit had been proved, the requirements of Section 9H had not been met and no benefits should be accorded the union. We will get back to this one. Right, now let's see what we have as far as literary material for practice. Oh, this is called For the Love of Language. Here we go. Before I knew stenography, I knew Japanese. I started learning it on my own in junior high, had formal education in the college classroom setting, and then did full immersion in Japan. After years of learning, I got to the point where I was using it on the job, and I have been a freelance translator for the better part of a decade now. So when I first dove into court reporting, I immediately looked at my court reporting classes as learning another language. Many elements of theory class and speed building reminded me of lessons in Japanese class, as they apply the same principles used in second language acquisition. The 4 pillars, not including the element of culture, language fluency, can be broken down into 4 chief skills: writing, reading, speaking, and listening. Skill for skill, stenography requires fluency in each to become a solid reporter. First, we must write this new language with its own unique alphabet of not only letters but also sounds and briefs. Next, we learn how to read our own notes and speak them aloud. The reason reading our notes aloud is encouraged in school is because the more quickly you read steno, the more easily you build speed. Lastly, listening. This by far is the most important of the steno skills. Stenography puts our listening skills to the ultimate test, where we have new grammar structures to contend with when learning another language. We want to learn to listen to our typically native language in an entirely new way as court reporters. Take the sample sentence: how many of the district attorney's documents have been brought into the courtroom in this case? No doubt many of you automatically honed in on the common briefs or 2 or 3 word phrases in that sentence. With practice, breaking down sentences like this becomes a subconscious reflex for court reporters, but it is something that must be learned as a student. Instructors often advise students to learn this skill by sitting in a higher speed class and simply listening in order to train their brains to process the information at a faster rate and have it translate directly from their ears to their fingers. Just as in learning a traditional language, the 4 skills of writing, reading, speaking, and listening must be learned and practiced in order to attain fluency in stenography. Quality, not quantity. In the case of learning a second language, it's often not how many words you know, but what word you know. Rather than tackling every possible word under the sun, smart learners need to put only 20% of their efforts towards learning the right words in order to achieve 80% comprehension, solely due to the frequency of those words. A capable language instructor will tailor vocabulary lists to cover only the most common words for that language. Train station may be almost obsolete in American society, but it's the central hub of a Japanese cityscape. Goat is associated more with Old MacDonald English preschools, but you'll encounter it in the first week of Vietnamese class because of its popularity in the country's dishes. It is for this same reason that court reporting instructors have students drill lists of the 1,000 most common English words. Our earliest briefs and phrases learned in theory are hand-selected because of their practicality and relevancy in a legal setting. You're not likely to learn evidence in your first few months of or even years of Spanish class, but it's one of the first words we learn in court reporting class. This focus on the most common sounds, words, and phrases is what quickly enables a student to become fluent in stenography, just as in any language. All right, back to our jury charge about the union complaint. Ready? Here we go. As noted, the complaint in the unfair labor practice proceeding was issued in February 1957, more than 12 months after the affidavit of August 30, 1955. Section 9H provides that no investigation shall be made or complaint issued on behalf of a union unless there is on file with the board a non-communist affidavit of each officer executed contemporaneously or within the preceding 12-month period. There was no charge against Peck for filing a false affidavit in 1955. The Court of Appeals met that difficulty by presuming that a person who was a communist in 1955 continued as such through 1956 and through the critical date of February 1957 in absence of evidence showing a change in the factual situation. The petitioner has also urged that Peck's conviction for filing a false affidavit could form no basis for holding the union in decompliance prior to the affirmance of Peck's conviction on appeal. At the time of the decision below, Peck's appeal was pending in the Court of Appeals for the District of Columbia. As noted, we have granted certiorari to review the affirmance of his conviction. We conclude that the sole sanction of Section 9H is the criminal penalty imposed on the officer who files a false affidavit, not decompliance of the union or the withholding of the benefits of the act that are granted once the specified officers file their Section 9H affidavits. Having so concluded, we find it unnecessary to reach the collateral phases of this controversy. All right, and that will conclude our literary and jury charge practice.